They are bound by the procedural and substantive law applicable to motion proceedings. A case in point being the manner in which the applicants formulated their first prayer in their notice of motion, I quote, "Condoning commencement of the criminal trial has already been delayed for too long." The applicant's notice of motion. As already intimated, the applicants request a number of different and diverse documents, and it is necessary to list in full the various documents as set out in the applicant's notice of motion, since varied aspects of the law are applicable to the duty of PG to disclose the different documents requested by the applicants. Paragraphs 2 to 7 of the applicant's notice of motion set out the relief they seek. Paragraphs 2.1 to 2.7 refer to documents that they request specifically in terms of Section 87 of the CPA and which they wish the court to compel the PG to make available to them. Such documents are in short the following: A, an updated indictment reflecting the changes that were made to it during the plea procedure. B, 2 hard copies of the disclosure which was provided by the PG to the erstwhile legal representatives of the 3 applicants. C, 2 hard copies of certain files disclosed in the Fishrot and Namibia cases. D, bilateral agreements between Namibia and the Republic of Iceland, the Kingdom of Norway, and the United Arab Emirates, in accordance with the provisions of the International Cooperation in Criminal Matters Act 9 of 2000, hereinafter referred to as the ICCMA, and subsequent to which certain information disclosed to the applicants were obtained. E, documentation evincing compliance with the provisions of the ICCMA in respect of the mutual legal assistance, hereinafter referred to as MLA, requests transmitted to various countries, and from which, as a result of the MLA requests, information was obtained, and which information the PG intends to use at the trial. And F, the responses from the countries mentioned in E supra, as well as the other countries from which MLA was sought, as per the Eastern and Southern African Anti-Money Laundering Group Mutual Evaluation Report on Namibia, document ESAA MLG in brackets 2022. Paragraph 3 of the relief sought simply states that if the PG has or had already included any of the documents as requested in paragraph 2 in the disclosure already made, the PG should indicate the location within the disclosure bundle of such documents. Paragraphs 4 to 6 proceed to request a number of additional documents and or information, but these prayers do not seem to be a request made in terms of Section 87 of the CPA, since the documents requested under that section were specifically listed in paragraph 2 and its subparagraphs, and Section 87 is not referred to at all in paragraphs 4 to 6. The further information and/or documents are as follows. A. The particulars relating to and the report or outcome of the investigations presumably done, if at all, under Section 83 of the Prevention of Organised Crime Act 29 of 2004, hereinafter POCA. B. Copies of all communication between the Anti-Corruption Commission, hereinafter the ACC, and the special investigators of the ACC appointed in terms of Section 14 of the Anti-Corruption Act 8 of 2003, hereinafter the ACA, before and after the concurrence of the Prime Minister granted on 5 March 2020, and culminating in the Deloitte report of 9 June 2021, and directing that the State furnishes to 2nd, 3rd, and 6th accused the following particulars of the meetings of the Integrated Investigation Task Force, hereinafter the IITF, conducted in the investigation of the complaints registered with the Anti-Corruption Commission in respect of cases CC 6 of 2021 and CC 7 of 2021, and specifically the dates of the meetings, the attendees at the meetings, and the minutes of the meetings. Paragraph 7 asks that the court adjourn the proceedings to such a date that will allow the PG to deliver the requested particulars and the applicants can examine same. The first applicant's founding affidavit. The first applicant deals in his founding affidavit with the requirements to be met by an accused person who seeks relief from the court in terms of Section 87 of the CPA. The requirements for successful application as understood by the first applicant upon his reading of Section 87 of the CPA are fivefold. The request must be made to the State. B. The request must be made at any time before evidence is led. C. The request must be made in writing. D. The request must oblige the State to furnish further particulars. And E. Those particulars must relate to a charge. He continues to deal at length with the manner in which he and his co-applicants have met all 5 requirements by referring to court to annexes to the founding affidavit, evidencing written requests for various documents, only some of which are mentioned in the notice of motion, as well as expounding on how each requested document relates to which count in the indictment. The court is further referred to an order made by Judge Liebenberg on 22 April 2021, which orders full disclosure by the State to counsel for the respective accused by no later than 6 May 2021 in hard copy. It seems to be common cause that although some disclosure was made before the due date set by Justice Liebenberg, substantial additional disclosure was made by the PG during June 2022, June 2023, and February 2024. During July 2025, the PG responded to a request from the attorneys of accused 7, 8, and 9, also being the attorneys of the entities these 3 accused represent, whereby the following documents were disclosed to the accused. A. The referrals from the Director of the ACC to the PG in terms of Section 31 of the ACA, and the report in terms of which Deloitte was appointed as a special investigator in terms of Section 14 of the ACA. It would appear that the total number of pages disclosed thus far exceeds 165,000. Paragraphs 68 to 72 of the first applicant's founding affidavit deals with the disappearance of his personal SWAPO files from his residence and are irrelevant to the proceedings before court. The first applicant concludes his founding affidavit with the following paragraphs. I quote, paragraph 75. The facts relating to the efforts taken by second, third, and sixth accused are self-explanatory and irrefutable. If the court does not grant the relief sought herein, not only will we be without a remedy, but we will also without doubt be subjected to an unfair trial. Paragraph 76. In the documents marked as correspondences 27.1 to 27.6, various other documents are specifically requested. I invite the court in its determination of the application to have regard thereto and grant relief of a wide and reasonable nature, so as to obviate the need for any further applications being made in the future seeking further disclosure. End quote. The PG's answering affidavit. The PG states that the applicants are not entitled to utilize Section 87 of the CPA to bring an application before this court to request the delivery of specific documents, since Section 87 is only applicable where an accused requests further particulars to a charge pending before the court. In paragraph 15 of the answering affidavit, the position of the PG is stated thus, quote, documents remain what they are, and they can never be a particular of a charge, end quote. She further states that the application before court is simply a continuation of the applicant's continued strategy of bringing one application after another in order to delay the commencement of the criminal trial, and that all the documentation that the applicants are entitled to by law has already been disclosed to them. The PG acknowledges that the state had during court proceedings undertaken to provide the applicants with an additional hard copy set of disclosure, and that same will be delivered to them once the copying thereof has been completed. She further asserts that there are no bilateral agreements in terms of the ICCMA between Namibia on the one hand and Norway, Iceland and the UAE on the other, but states that the requests for MLA were made in terms of the United Nations Convention Against Transnational Organized Crime, as well as in terms of the United Nations Convention Against Corruption, and that Namibia is a party to both these conventions. Furthermore, in terms of the ICCMA, the request for MLA consists solely of correspondence between the relevant countries, and as such they cannot be disclosed to anyone. The PG states that the documentation requested in paragraphs 4 and 5 of the applicant's notion of motion forms part of the investigation diary. She states that if it is their contention that they are entitled to such, they should have set out the facts whereupon they base their assertion that it will assist them in the preparation of their case, and on what ground they claim that it will assist them in proving their innocence. As regards the documents requested in paragraph 6 of the notice of motion, the PG categorically denies that those documents form part of the docket and continues to state that the applicants cannot expect her to investigate their case for them. The first applicant's replying affidavit. It is necessary to mention that the first applicant's replying affidavit consists of more than 150 pages, of which approximately 120 constitute additional annexes to the replying affidavit. Suffice it to say that much more was stated in the affidavit than was necessary to reply to the 13-page answering affidavit of the PG. I will endeavour to summarize the relevant points made by the first applicant as succinctly as possible in order not to unnecessarily burden the length of this ruling. It is the first applicant's contention that the mere fact that some evidence were obtained in the absence of bilateral agreements between the various countries, as envisaged by the ICCMA, affects not only the admissibility of the evidence, but also the legality thereof. The first applicant deems the reliance of the PG on the UNCATOC and UNCAC as a basis for the internationally obtained evidence against him as being misplaced, and invited her to obtain a legal opinion from the Attorney General on this specific point. The first applicant proceeded to state that the PG's assertion that no one is entitled to have insight into the requests for MLA is presumably based on Section 2, capital letter A, of the ICCMA, and that a reading of the section is incorrect, since she loses sight of the contextual ambit of the ICCMA, and specifically Section 6 thereof. The first applicant embarked on a detailed exposition of certain correspondence and documents that have been disclosed by the PG, and how that correspondence and documentation relate to the documents that they are now requesting to be disclosed. The first applicant, in effect, invites the court to go with him down a proverbial rabbit hole of references and cross-references to documents and correspondence, but the court will decline such invitation. The fact of the matter remains that the first applicant is, by the mere fact of the civil procedure that he chose to follow in this criminal court, bound by what he prays for in his notice of motion and founding papers. The information contained in his replying affidavit by far exceeds those bounds. As to the contention by the PG that the applicants are requesting disclosure of the investigation diary, the first applicant denied that his request for further particulars, and particularly paragraph 4 of the notice of motion, where he requests the police report following an investigation pursuant to Section 83 of POCA, forms part of the investigation diary. The first applicant next turns to the relief requested in paragraph 5 of his notice of motion and the PG's reply thereto in her answering affidavit. In paragraph 51 of his replying affidavit, he specified that he requests the director of the ACC's appointment in terms of Section 14 of POCA of the special investigator being the firm of Deloitte. Reference is made to a report from Deloitte marked as Annexure SES RA in brackets H. From the first applicant's reading of such report, it is argued in the replying affidavit that information was extracted from devices. In order to facilitate the process of extraction, the devices were sent out of Namibia to the Republic of South Africa and back again. The first applicant's contention is that the correspondence relating to the chain of evidence of these devices needs to be disclosed in order for him to establish whether any unlawful activities occurred during this process. Again, these assertions exceeds the bounds within which a replying affidavit should stay. The PG in her answering affidavit stated that the documents sought by the applicants in paragraph 6 of the notice of motion never formed part of the docket, this being the documents relating to the IITF, which was established to investigate the matters which, according to the applicants, form the basis of the criminal matter at hand. Against articles, social media clips, and other documents in order to bring home his point in this regard, all of which, contained in paragraphs 61 to 67, are new facts which ought to have been but were not raised in the founding affidavit. The following has again recently been stated in Ileka and Another versus Namibia Post Limited at paragraph 25. I quote, "The general rule has been laid down repeatedly that an applicant must stand and fall by the founding affidavit and the facts alleged therein, and that although sometimes it is permissible to supplement the allegations contained in that founding affidavit, the foundation of the application is the allegations contained in the founding papers, because those are the facts that the respondent is called upon either to affirm or to deny. The general rule, therefore, is that an applicant must make out his case in the founding papers and not in the replying papers." End quote. The first applicant contends that he needs disclosure of the documents relating to the activities of the IITF and the PG's role therein in order to ascertain the legality of the investigations which led to his and his co-accused's arrest. Paragraphs 68 to 71 deal with the fact that the Deloitte report was only finalized during June 2021 after the state brought an application to join Criminal Case 6 of 2021 and Criminal Case 7 of 2021 in May 2021. First applicant suggests that an application might be brought under Section 65 or 76 of the rules to request disclosure of which documents is not clear to the court. Paragraphs 73 to 123 of the replying affidavit consist of an ad seriatim reply to the answering affidavit of the PG, and the following statements can be highlighted. A. The PG has no authority in law to conduct a prosecutor-guided investigation. B. The PG is guilty of selective disclosure based on the lens of those seeking conviction. And C. The first applicant reiterates that the PG is guilty of selective disclosure, specifically of the documentation and information surrounding the IITF's activities, and states that that information is the genesis of the docket which forms the basis of this case. The applicant's case. The applicants prepared heads of argument which were supplemented by oral argument delivered on the day of the hearing. To counter the argument of the PG that the applicants erroneously used Section 87 of the CPA to request further particulars, the applicants referred to the court to State v. Scholes at page 6, I quote, "If disclosure of statements of prosecution witnesses falls within the ambit of Article 12 of the Constitution, then such disclosure constitutes one of the important elements of a fair trial. Non-disclosure of relevant material might therefore be vulnerable to attack on this ground. It is therefore of no consequence that the Criminal Procedure Act does not have a provision for a general right of disclosure of materials in a police docket as submitted by Ms. Winson for the applicant. The right resides in Articles 7 and 12 of the Constitution." End quote. In support for the proposition that the applicants are entitled to all that is contained in their prayers in the notice of motion, the court was referred to a number of Commonwealth cases, among which the South African case of State v. Shabalala, the English cases of Rex v. Moorf and Rex v. Ward, as well as the Canadian case of Rex v. Stinchcombe. I will deal with these referenced cases more fully below. The applicants also addressed the issue of public interest immunity, which holds that the state is entitled to withhold the information contained in a docket from accused persons where its disclosure would be detrimental to the public interest. The PG does not rely on public interest immunity, and thus I will not deal with this part of the applicant's submissions. It was the applicant's submissions that a proper disclosure engages Article 18 of the Namibian Constitution, and to refuse to disclose without no factual averments to justify refusal, is to frustrate the enjoyment of a fundamental right to a fair and reasonable prosecution decision by making it impossible to review the decision. As to the PG's reliance on the provisions of the UNCATOC and UNCAC for the requests for MLA from countries that are not a party to the ICCMA, the applicant submitted at length that Namibia is a sovereign state and that domestic law trumps any international convention that Namibia is a party to. In this regard, the court was referred to a number of authorities, among others Articles 1 subsection 1, 1 subsection 6, 63 and 144 of the Namibian Constitution, the case of Natal Joint Municipal Pension Fund versus Indumeni Municipality, Articles 31 and 32 of the Vienna Convention on the Law of Treaties and the legislative guides drafted by the United Nations Office on Drugs and Crime. The applicants concluded by stating, I quote, "The ACC cannot, for instance, exchange emails with foreign agencies and obtain information in an investigation in that fashion," end quote, and concluded that it was unlawful for the PG to rely on the provisions of the UNCATOC and UNCAC in the absence of bilateral agreements concluded in terms of Section 27 of the ICCMA. The applicants further submitted that the PG's reliance on Section 2A of the ICCMA should be read in conjunction with Section 6 thereof, which provides that evidence obtained subsequent to a letter of request shall be open to inspection by the parties to such proceedings. The whole paragraph 5 and its 10 subparagraphs of the applicant's heads of argument deal first with the disclosure that has already been made by the PG, followed by a request for specific additional documents to the disclosure already made. For instance, I quote, "The document SESRA in brackets I is an indication that the devices were taken to South Africa. The chain of custody documents are not disclosed," end quote. The position of the applicants is summarized in paragraph 6.5 of the heads of arguments. I quote, "As we have shown, if full disclosure is not made, we will be denied the full context of the initiation of the investigation, the conduct of the investigation, the process of how the information was obtained locally and in foreign jurisdictions, how the information was handled locally and in foreign jurisdictions, and whether or not the law was adhered to. That will amount to the prejudice that affects our fair trial rights," end quote. The PG's case. Mr. Bernardt Esau, on behalf of the PG, did not prepare written heads of argument and simply addressed the court on the day of the hearing. He drew attention to the fact that many points were raised in the replying affidavit of the applicants that were not raised in the founding affidavit, and that new issues raised only in the replying affidavit should not be considered by the court. It was submitted that Shabalala and schools were decided at the advent of the constitutions in both South Africa and Namibia, and that the courts in those cases dealt with the duty of the state in the light of the new constitutions to disclose to accused persons witness statements and documents that the state will rely on at the trial. According to counsel, since such a duty did not exist before the enactment of the two constitutions, the decisions should be read in the historical context in which they were delivered. He contended that such documents and witness statements have been disclosed to the applicant and that the documents they request in the notice of motion fall outside the ambit of those decisions. Mr. Marondetse relied on Section 30 of the ICCMA as authority for the submission that the existence of bilateral agreements for MLA in terms of the ICCMA is not a prerequisite for the admissibility of evidence obtained from international sources. It was further submitted that Section 30 of the ICCMA should be read in conjunction with Article 18 of the UNCATOC, which governs MLA between both countries that have bilateral agreements with each other and those that do not. The court was specifically referred to Article 18, subsection 2, which reads as follows, I quote, "Mutual legal assistance shall be afforded to the fullest extent possible under relevant laws, treaties, agreements, and arrangements of the requested state party with respect to investigations, prosecutions, and judicial proceedings to the offences for which a legal person may be held liable in accordance with Article 10 of this Convention in the requesting state party," end quote. In respect of the various requests for MLA that were sent abroad, Mr. Marondetse submitted that Section 2A of the ICCMA specifically prohibits the disclosure of such requests. The state relied heavily on Shueda versus the state to bolster their position that the applicants are not entitled to disclosure of the investigation diary in the docket. A more detailed discussion of the principles enunciated in the case will follow below. It was submitted that all the documents requested in paragraph 5 of the applicant's notice of motion form part of the investigation diary, with the exception of the appointment in terms of Section 14 of the ACA, which had already been disclosed. It was submitted on behalf of the PG that the state had already bent over backwards to accommodate the applicant's various requests for documents, going even so far as to disclose a docket to them which does not form part of the state's case against them. Documents requested by the applicants which do not form part of any police docket were also provided to them upon their request. Mr. Marondetse restated the PG's stance that it cannot be expected from her to do the applicant's investigation for them. Emphasis was furthermore placed on the fact that the PG provided the applicants with a detailed pre-trial memorandum, and that not one of the accused elected to reply thereto. Mr. Marondetse reiterated the state's position that they are not in possession of any of the documents requested under paragraph 6 of the notice of motion, being the details of the meetings of and the investigation done by the IITF. The applicable law. The Namibian Constitution is the supreme law of the country and was adopted on 9 February 1990. With its advent, the right to a fair trial was given constitutional protection through Article 12 thereof, which states that persons shall be afforded adequate time and facilities for the preparation and presentation of their defence before the commencement of and during their trial. The court ruled in State v. Novasep at paragraph 22 that adequate facilities include copies of witness statements and other evidential documents. Before the coming into operation of the Constitution, both in Namibia and in South Africa, accused persons were not entitled to have insight into witnesses' statements and other evidential material that the state would use against them in a criminal trial. But that position was changed drastically with the landmark South African decision of Shabalala and the Namibian decision in Scholz. Subsequent to Scholz, the following was said in States v. Kanduvazu at paragraph 5. I quote, "The issue here is the meaning of a fair trial and whether or not that constitutional guarantee can live side by side with the blanket docket privilege that the state enjoyed under the common law. Article 12.1a has a wide and all-embracing purpose, in my view. It provides, in the determination of their civil rights and obligations, or any criminal charges against them, all persons shall be entitled to a fair and public hearing by an independent, impartial, and competent court or tribunal established by law. Article 12 then sets out some instances of a fair trial that fall within that umbrella. For example, Article 12.1e, it says, all persons shall be afforded adequate time and facilities for the preparation and presentation of their defence before the commencement of and during their trial. The expression facilities for preparation and preparation of their defence referred to in the article above must go beyond the physical facilities in which to prepare the defence. It must include, in my opinion, information to be presented as part of the defence case. It would be difficult to hold that adequate facilities for preparation and presentation of the defence case within the meaning of Article 12.1e were given when the facilities provided did not give the defence the opportunity to examine the state witness statements in an appropriate case, unless a case were made out by the party seeking to withhold the information." End quote. It is thus clear that the law in Namibia now embraces the concept that a blanket docket privilege no longer exists, and whether an accused remedy for compelling the state to disclose the information and or documents lies in an application in terms of Section 87 of the CPA or not is neither here nor there, since it is abundantly clear from the case law that the right resides in the Constitution. The applicants referred the court to the English cases of Ward and Moyer. In both of these cases, it came to light after the various accused had already been found guilty of planting bombs that led to a number of deaths. The prosecution had, deliberately it would appear, withheld scientific reports that formed part of the docket and which was obviously not disclosed to the defence. The dicta in those two cases clearly dealt with the ethical duty of the prosecution to disclose all relevant information in a docket, even where such information contained exculpatory evidence which would have assisted the accused in their defence. These cases thus only reiterate the current position in Namibia, namely that the defence, especially in complicated cases, is entitled to copies of witnesses' statements and other relevant documents that are contained in the docket, and that the state has a duty to disclose same. These the applicants in the matter at hand already have. The question that this court is faced with is whether they are entitled to more. In other words, are they entitled to the contents of what is commonly known as the B and C part of the docket? The B part of the docket then also commonly known as the investigation diary. The North Gauteng High Court had the following to say when faced with a similar question in State v. Matotsi. I quote, "It is important to know the remarks of various judges as to the ends which this procedure is not intended to serve. It is not intended to force an opponent to disclose the evidence he intends to rely on at a trial. It is not intended by a process of interrogatories to allow the cross-examination of an opponent or to provide an opportunity for a fishing expedition or to afford an excuse for delaying the proceedings. It is plainly not the purpose of the particulars to 1. Enable either party to find out what evidence his opponent intends to rely on, nor 2. To obtain information on which to build up an answer to the pleadings or indictment, in other words, information not about the opponent's pleading or indictment, but on matters arising out of the pleading or indictment, pertinent only to his defense and not to his opponent's allegations. The person who applies for particulars, in this instance accused 10 and 11, must show some instances entitling him or her to, such as without the particulars which he seeks, he would be embarrassed in pleadings, or that he is unable to understand fully and in detail the case sought to be made against him. The request must be reasonable, and the particulars must be necessary for the purposes of pleading. The state cannot be forced to give accused 10 and 11 particulars which will enable him to build up his case. End quote. Heemstra's criminal procedure issue 7 at page 14/24 states as follows, I quote, "Courts must guard against the abuse of Section 87 where the accused's aim is not to advance the proper administration of justice, but rather to obfuscate the issues. In this regard, see State v. Chow. The court should assess whether adequate information has been given to the defense with regard to the following questions. A. Does the accused need the information to answer to the charge? B. Would a refusal to give the particulars prejudice the accused? C. If the particulars are requested after plea, before evidence has been led, what is the relevance of the particulars? D. What does the interest of justice dictate?" End quote. Judge Miller in State v. Kennedy, relying on his previous dictum delivered in Shueda, stated as follows at paragraphs 10 to 11. I quote, "In Matthias Shueda v. the State and others, this court dealt with the issue of disclosure of the investigation diary and of particular relevance are paragraphs 13, 14, 15, and 16 of the judgment. The relevant portions reads as follows. Applicant who seeks to establish the right to disclosure of the investigation diary bears the onus of proof that the refusal of the second respondent to disclose the diary infringes his right to a fair trial. Applicant's case rests purely on speculation that there might be information in the diary that might assist him in preparing his defense. There is absolutely no evidence how the documents disclosed fails to assist the applicant in the preparation of his case, nor is there evidence how the information in the diary would assist the applicant. Applicant fails to make a case in the founding affidavit, and for that reason alone, the application should fail. I now turn to consider whether the words information contained in the police docket should be understood to embrace the investigation diary. In my view, the words must be read down to give them a restricted or limited meaning of referring to the witness's statements. And relevant documents relating to the case prepared by the prosecution against the accused. In all the foreign authorities cited in the Skoldsmith matter, the words used in reference to the disclosure of statements are material documents or information. Relevant material, i.e., evidence which is tended either to weaken the prosecution or to strengthen the defense case. Witnesses' statements, relevant evidence, material evidence which the prosecution gathered and from which the prosecution have made their own selection of evidence to be led. documents that are material or relevant to the offences with which the accused is charged, all relevant information. In the case of Rex versus Haikul, referred to at 225b, in the Scholes matter, it enumerates classes of documents required to be produced for discovery, but the investigation diary is not one of them. It is my view that that is the case for the reason that an investigation diary is not a relevant evidence or information for disclosure. Thus, the words information in the police docket must read to mean only relevant material, documents, or information, including witnesses' statements, whether or not the prosecution is going to use the information. In applying the approach adopted and the principles apparent from the relevant passages, I remain unpersuaded that the applicant is entitled to the disclosure of the investigation diary. He simply fails to make out any case for that relief." End quote. The South African Law Commission's discussion paper 90, Project 101, entitled "The Application of the Bill of Rights to Criminal Procedure, Criminal Law, the Law of Evidence and Sentencing, 2000, and prepared for the Commission by Professor Swickard, has the following to say at page 51, I quote, "The words facilities means," the Namibian High Court quoted in State v. Nasser, "facilitating or making easier the performance of an action. The right to have facilities implies a claim against somebody or someone to facilitate or make easier the preparation of a defense. In the context of the Bill of Rights, the claims are certainly against the state, imposing a positive duty on it to assist. As the word facilities is not self-limiting, it holds the potential of being expansively interpreted to place an accused in a position similar to that of the prosecution, with state-appointed investigators, access to laboratory expertise, expert witnesses, etc. The state's obligations are, however, limited in three ways. First, as the right arises only when an accused does not have access to a particular facility, an accused must show a particular need. This requirement will be met most readily by indigent and imprisoned accused who cannot afford a particular facility. Secondly, the need must relate to the preparation of a defense. The onus will be on the accused to show why a particular facility is required. Third, the state's obligation is confined to the provision of facilities that are adequate. The adequacy of the offered facility falls to be determined by the court and is not dictated by the accused." End quote. In National Director of Public Prosecutions v. King, the Supreme Court of South Africa again had the opportunity to discuss the different parts of the police docket and to decide whether an accused has a right to ask for disclosure of the whole of the docket. The following was said at paragraphs 2 to 4, I quote, "The blanket privilege has not been replaced by a blanket right to every bit of information in the hands of the prosecution. Litigation privilege does still exist, also in criminal cases, albeit in an attenuated form as a result of these limitations. Litigation privilege is in essence concerned with what is sometimes called work product and consists of documents that are by their very nature irrelevant because they do not comprise evidence or information relevant to the prosecution or defense. This much is hardly contentious. What is in contention in this appeal is whether an accused is entitled as of right to a full description of each and every document to which he is denied access, all being documents falling in parts B and C of the document, with a statement of the precise basis upon which access is denied to any document in order to have a fair trial. In other words, is the accused entitled to a motivated index to satisfy him in advance that the trial will be fair? The court below held in the affirmative, and hence this appeal by the National Director of Public Prosecutions. It is well to remind oneself at the outset of a number of basic principles in approaching the matter. Constitutions call for a generous interpretation in order to give full effect to the fundamental rights and freedoms that they create. The right to a fair trial is, by virtue of the introductory words to Section 35, subsection 3 of the Bill of Rights, broader than those rights specifically conferred by the fair trial guarantee therein, and embraces a concept of substantive fairness that is not to be equated with what might have passed muster in the past. This does not mean that all existing principles of law have to be jettisoned, nor does it mean that one can attach to the concept of a fair trial any meaning whatever one wishes it to mean. The question remains whether the right asserted is a right that is reasonably required for a fair trial. A generous approach is called for. This is a question for the trial judge, and there is in general not an a priori answer to the question whether a trial will be fair or not. Potential prejudice may be rectified during the course of the trial, and the court may make preliminary rulings depending on how the case unfolds, and may revoke or amend them. Irregularities do not lead necessarily to a failure of justice." End quote. As to the relationship between the United Nations Conventions to which Namibia is a party and domestic law, this court can do no better than to refer to what was said in Prosecutor General and others v. Shilingudwa. I quote, "The Palermo Convention. Our POCA is modelled on the Palermo Convention, the groundbreaking convention adopted by the United Nations in the Italian city of Palermo in December 2000. While the convention per se cannot determine the validity of the Namibian legislation as argued by the Prosecutor General, it is indisputably an aid to its interpretation. The Convention represents the international community's response to a global challenge of cross-border crime and the emergence of organized crime and its various manifestations. According to the preamble to the Convention, the parties were convinced that the Convention would constitute an effective tool and the necessary legal framework for international cooperation in combating transnational organized crime and terrorist crimes. Article 1 identifies the Convention's primary purpose as the promotion of cooperation in the effective prevention and combating of transnational organized crime. The approach advocated in the Convention may not be universally followed, and each party to it is at liberty to charge its own legislative path within the tenor and spirit of the Convention. However, when the domestic legislation of a party to it is impugned, as is the position in the current proceedings, the Convention may be prayed for in aid in search of a constitutionally compliant interpretation. The Convention is part of international law, which our Constitution and country honor. In fact, being binding on Namibia, the Convention has become part of our law by virtue of Article 144 of the Namibian Constitution." End quote. The law applied to the relief requested by the applicants. At paragraph 2.1, An updated indictment has already been delivered to the applicants. At paragraph 2.2, Mr. Bernardt Esau has undertaken to deliver an additional hard copy set of the disclosure to the applicants. At paragraph 2.3, the applicants refer to in the notion of motion to certain files in the Namibia and Fishrot files, and never again. If those files form part of the disclosure that has already been made to the applicants, the request in this paragraph for a hard copy of such files should logically also be included in the promised hard copy of the disclosure as mentioned above. At paragraph 2.4, the PG in her answering affidavit stated that there are no bilateral agreements in terms of the ICCMA between Namibia and Norway, Ireland and the UAE, and thus she is not able to disclose such agreements. At paragraph 2.5, the applicants request the letters of request for MLA purportedly obtained in terms of the ICCMA. The PG responded that such letters of request were sent in terms of the provisions of Section 30 of the ICCMA, the provisions of UNCATOC and UACAC. Section 30 of the ICCM states as follows. I quote, "Act not to limit provisions of other assistance. Nothing in this act contained shall be construed so to as prevent or abrogate or derogate from any arrangement or practice for the provision or obtaining of international cooperation in criminal matters otherwise than in the manner provided for by this act." End quote. The wording of Section 30 cannot be clearer than it is. Should a party wish to use any other means than what is contained in the provisions of the ICCMA to obtain MLA, they can do so. Shilangudwa is furthermore clear authority for the proposition that treaties and conventions to which Namibia is a party forms part of the Namibian law in terms of Article 144 of the Namibian Constitution. Article 18, subsection 7 of UNCATOC reads as follows. Paragraphs 9 to 29 of this article shall apply to requests made pursuant to this article if the state parties in question are not bound by a treaty of mutual legal assistance. If those state parties are bound by such a treaty, the corresponding provisions of that treaty shall apply, unless the state parties agree to apply paragraphs 9 to 29 of this article in lieu thereof. State parties are strongly encouraged to apply these paragraphs if they facilitate cooperation, while the corresponding article of UNCAC, being Article 46, subsection 1 and 7, state the following, I quote, "Mutual legal assistance. State parties shall afford one another the widest measure of mutual legal assistance in investigations, prosecutions and judicial proceedings in relation to the offences covered by this convention." Paragraph 9 to 29 of this article shall apply to requests made pursuant to this article if the state parties in question are not bound by a treaty of mutual legal assistance. If those state parties are bound by such treaty, the corresponding provisions of that treaty shall apply, unless the state parties agree to apply paragraphs 9 to 29 of this article in lieu thereof. State parties are strongly encouraged to apply those paragraphs if they facilitate cooperation. End quote. The applicants informed the court that they are requesting these requests for MLA to enable them to verify the legality and not only the admissibility of the information the state obtained against them from other countries. I am not convinced that in this context there is a discernible difference between the concepts of legality and admissibility. It is the general rule that if evidence is not obtained legally, it is not admissible. Our court has very recently stated in Nghipunya versus the Prosecutor General of Namibia and others at paragraph 109 that the issue whether the documents are inadmissible should be raised at the criminal trial and should be decided by the trial judge. The PG further made a valid point in stating that Section 2A of the ICCMA prevents the PG from disclosing such letters of request. The relevant section states as follows, I quote, "Non-disclosure of requests for assistance. Unless otherwise authorized by law, a person who, because of his or her official capacity or office, became aware of the request for assistance and has knowledge of a. The contents of the request for assistance made under this Act, b. The fact that the request for assistance has been or is about to be made, or c. The fact that the request for assistance has been granted or refused, shall not disclose the contents or the facts of such request, except to the extent that the disclosure is necessary to execute the request for assistance from a foreign state." End quote. Applicant submitted that Section 2A should be read in the context of what is contained in Section 6 of the ICCMA. I quote, Section 6, inspection of evidence obtained by letter of request. Where a letter of request is issued after proceedings have been instituted, the evidence so obtained, together with a record of the proceedings at the examination of the witness, shall be open to inspection by the parties to such proceedings. End quote. It should be abundantly clear that Section 6 refers to the evidence obtained as a result of request for MLA, thus clearly distinguishing it from the letters of request itself, which are dealt with in Section 2A. Even if it should be argued that Section 2A of the ICCMA only applies to letters of request for MLA issued under the Act itself, Article 18 subsection 20 of UNCATOC and Article 46 subsection 20 of UNCAC, upon which the PG rely, contain similar provisions. Even if it is further argued that the requests for MLA do not fall under the statutory exclusions as discussed above, I am still of the opinion that the letters for MLA are excluded on the grounds stated in King above, namely that the abolition of the blanket docket privilege was not replaced with a blanket access to the docket, and what was specifically mentioned in King was work product, which, according to the South African Supreme Court, still falls under what is called litigation privilege. I find that the request by the applicants of the letters of request for MLA falls under this privilege and that they are thus not entitled to disclosure thereof. At paragraph 2.6, the applicants request the responses from the countries to which letters requesting MLA were sent. This is a net that is cast very wide. No specific documents are requested, neither in the notion of motion nor in the founding affidavit deposed to by the first applicant, which renders this prayer of the applicants vague. As already stated at the outset of this ruling, the applicants chose to proceed by means of notice of motion procedure and are accordingly bound by their founding affidavit. A detailed replying affidavit was filed where mention is made of specific documents of foreign origin and specific information is requested. This, however, matters not because it is right that the applicants are required to stand or fall by their founding affidavit. The court finds that the reasons above not to order for the delivery of further particulars no order can be made for the request for further particulars as in paragraph 2.6 of the notice of motion. At paragraph 3, The applicants request that if any of the requested documents had already been disclosed by the state, such location within the disclosure should be provided to them. The court is in agreement with the general concern raised by the applicants. The court cannot foresee how the trial can possibly proceed in an organized fashion without the at least 165,000 pages of disclosure being properly indexed and organized. Such indexing and or pagination will have to be done with inputs from all the parties and will be dealt with by means of a status hearing, which will be scheduled by the court in due course. At paragraph 4, the applicants request the report compiled by the police under Section 83 of POCA. Section 83 reads as follows, I quote, "Whenever the Inspector General of Police or the Director General of the Anti-Corruption Commission has reason to believe that any person may be in possession of information relevant to the commission or intended commission of an alleged offence in terms of this Act, or any person or enterprise may be in possession, custody or control of any documentary material relevant to that alleged offence, he or she may, prior to the institution of any civil or criminal proceedings under written authority, direct a particular member of the police or an authorized officer of the Anti-Corruption Commission to investigate a specific offence." End quote. Nowhere in the section is any mention made of a report, and it is thus unclear to which report the applicants are referring to. The court cannot order disclosure of a report requested in terms of Section 83 of POCA if the provision relied upon does not make provision for the compilation of a report. One would assume that the outcome of the investigation that the applicants refer to in their prayer is in fact the contents of the docket which has already been disclosed to the applicants. At paragraph 5, Paragraph 5 of the Notice of Motion requests all communication between the ACC and the special investigators, being Deloitte, which was appointed in terms of Section 14 of the ACA. The PG in our answering affidavit stated that such communication form part of the investigation diary and that they thus do not form part of the documents that need to be disclosed to the accused persons. What is abundantly clear from the above cited jurisprudence in both Namibia and South Africa is that the applicants have to make out a case that a portion of the investigation diary is relevant to their defence preparation. The point is further bolstered by the guidelines provided in Imstra's criminal procedure, as well as in the application of the Bill of Rights to criminal procedure, criminal law, the law of evidence, and sentencing as referred to above. Paragraph 67 of the founding affidavit of the first applicant states as follows, I quote, "Lastly, that the state may or may not use the particulars, documents and information sought herein is neither here nor there. However, the accused persons may find material which is either merely relevant to their defence or relevant and capable of being admitted by the court as evidential material to utilize in their defence, something which the state may not be capable of discerning and determining from the perspective of the prosecution." End quote. As I understand the relevant case law and academic sources, reasons specific enough for this court to meaningfully exercise its discretion should be advanced in the founding affidavit of the applicants in order to justify an order compelling the state to disclose the investigation diary. A blanket assertion as contained in paragraph 67 as above of the founding affidavit simply will not suffice because it lacks the necessary specificity to place the court in a position to decide whether the requested portions of the investigation diary is of relevance to the defence preparation of the applicants or not, and also whether it is necessary for the applicants to answer to the charge against them. I am satisfied that the applicants have not made out the case for the court to grant the relief as requested in paragraph 5 of the applicant's notice of motion. At paragraph 6, Paragraph 6 of the Notice of Motion requests details of the meetings and investigations of the IITF. The PG states that those documents never formed part of the docket. The dilemma that courts are faced with in applications for disclosure in criminal cases has been stated thus in State v. Lamek at paragraph 19 to 20, I quote, "The difficulty which arises for the court is that it will not know whether the information requested by the accused is contained in the docket. In that respect, the court must rely on what the parties say. If, as in the instant case, the state alleges that the information is contained in the contents of the docket which was disclosed to the accused, and that is not challenged, the court will accept the assurance given by the state," end quote. The first applicant, in his replying affidavit, cites a number of documents that were disclosed to them and which he attached to the affidavit. These documents are varied, and the court is not sure whether it is his contention that these documents have their origin from the meetings of the IITF. They are not placed in context of what is requested in paragraph 6 of the notice of motion. If the PG says that she is not in possession of the investigative material of the IITF, then this court must take her word for it, as per Lamek above. If the PG is not in possession of the documents that the applicants request, then logically the applicant's remedy lie not against her, but against the institutions who are, whomever they be. Conclusion. Because of the similarities between the case at hand and the King case, it is apposite to conclude with what was said in King at paragraph 5, I quote, "There is no such thing as perfect justice, a system where an accused person should be shown every scintilla of information that might be useful to his defense, and discovery in criminal cases must always be a compromise. Fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that the accused's right should be subordinated to the public's interest in the protection and suppression of crime. However, the purpose of the fair trial provision is not to make it impracticable to conduct a prosecution. The fair trial right does not mean a predilection for technical niceties and ingenious legal stratagems, or to encourage preliminary litigation, a pervasive feature of white-collar crime cases in this country. To the contrary, courts should, within the confines of fairness, actively discourage preliminary litigation. Courts should further be aware that persons facing serious charges, and especially minimum sentences, have little inclination to cooperate in a process that may lead to their conviction, and any new procedure can offer opportunities capable of exploitation to obstruct and to delay. One can add the tendency of such accused, instead of confronting the charge, of attacking the prosecution," end quote. Following the above, the proverbial flip side of the coin is that our courts do not look kindly on trial by ambush, and should the prosecution wish at trial state to use information or documents that were not disclosed to the accused persons involved in this case, they will most certainly have to make out a case for such to be done. This is then the court's order. In view of the considerations and conclusions recorded above, the court is of the view that the following order is appropriate. 1. An additional hard copy set of the disclosure is to be delivered by the state to the applicants not later than 15 September 2025. If the files mentioned in paragraph 2.3 of the applicant's notice of motion formed part of the previously electronic version of the disclosure, such files must be included in the hard copy set of the disclosure that is to be provided as per this order. 2. The prayer for the disclosure of the bilateral agreements as per paragraph 2.4 of the notice of motion is dismissed. 3. The prayer for the disclosure of the matters of letters of request for MLA as per paragraph 2.5 of the notice of motion is dismissed. 4. No order is made in respect of paragraph 2.6 of the notice of motion due to the vagueness thereof. 5. The prayer as per paragraph 4 of the notice of motion for the disclosure of the report generated subsequent to section 83 of POCA referral is dismissed. 6. The prayer as per paragraph 5 requesting copies of the correspondence between the ACC and Deloitte is dismissed. 7. The prayer as per paragraph 6 of the notice of motion requesting copies of the investigations carried out by and details of meetings held by the IITF is dismissed. 8. The parties are directed to attend a status hearing at 10 o'clock on 15 September 2025, where the indexing of the disclosure will be discussed and formalized. Mr. Shanghala?
Yes, Judge. First, I'd like to apologize that we came late.
Yes, I wanted to inquire why that happened.
You see, Judge, despite your lengthy judgment on all these niceties of law, we're not getting a fair trial. If I can't be brought to court even on time, the competence of the police and the NCS has no boundaries, and it has been on display following the tragic passing of these officers in Marienthal, just organizing a funeral. In any event, I also wanted to, so we were ready, we were not picked up. It wouldn't happen if I was, for example, on bail, would be here on time. Anyway, I also wanted to tell you that, and inform you, that the judgment was rendered in the matter relating to the appointment of Justice Chinengo, and the court did not agree with us. It turned down our application. Thus, my days will run out on the 19th to file an appeal. I have gone to great length at drafting the appeal. I have just not yet filed it yet. I intended to do it on the 15th, but I'll do it on the 16th now, given the court order. I also wanted to inquire from the court what the court intends to do. Would we commence de novo or would we proceed? And if the court would like to be addressed on that issue, I would be prepared to advance arguments based on the High Court full bench judgment of S.V. Barman. Then also, on the 5th of September, we were entitled to receive, by court order, a report by the DG of the Office of the Judiciary and the Ministry of Justice. Hopefully, Judge, if you've read that court order, you won't read it down. It's very clear we're supposed to receive that by Friday. It hasn't happened. As
I understood it was Honorable Judge Mwatelulo was supposed to receive.
Well, let me read from the judgment order. It says, paragraph 3.2, file the report referred to in paragraph 3.1 of this order with this court and serve the report on the applicants by not later than 05 September 2025. It couldn't be clearer. You can't, that's why I was saying, you know, tongue in cheek, you can't read it down. It's so clear. So it didn't happen. When you were reading your order and judgment, some of my co-accused were moving about because it's uncomfortable. And the creaks that were generated, I just couldn't hear. So I'll probably wait for the judgment in its printed form so that I could read it proper, so that I can decide whether I want to appeal it or not. Judge, then I also wanted to request you to remind the prosecution. They had promised us they'd give us the electronic version of the indictment. it's still pending. And lastly, I wanted to address you on the issue of, you see, 2 years ago there was a judgment. Actually, in 2020 initially there was a judgment by Justice Parker, and then in 2023 the Supreme Court ruled that we shouldn't be transported in pickup bakkies. And I had been lamenting in this court from this very position I'm standing that some of us suffer from asthma. And when we sit in a metal cage and you are 9 of you, it's suffocating. Sometimes I feel dizzy. And in this heat, it is exacerbated. Now we have had the unfortunate incident of the loss of lives. We are transported in these vehicles without safety harnesses. Judge, I simply just love life. I do not want to be a statistic. I know that some may wish me dead, but until you are about to execute me, just grant me, at least the court order is clear. It was in the High Court and then in the Supreme Court. Please, so that we may avoid issues of, but he said, he was even saying, please, we are being transported in these vehicles. There are no safety harnesses. It's just not safe for my lung capacity. I'm not Superman, please. If you can just, it's the same thing. Court orders, we must comply with them, but they're not complied with by, the state. When the court says, provide a report by the 5th, we read the same thing, it's different for others. What if I decide I'm just sitting down now also? Because, statistically, by the way, Judge, I have yet to come across any where, whether it's sports, whether it's war, whether it's whatever, where statistically one side loses all the time. It's just, in this case, CC 06-2021, it's just amazing. But anyway, the court rules are there for all of us, including the court itself, to be an arbiter of fairness. So I hope that the case, I can refer you to the case. It's SA 69 of 2020 in the Supreme Court, Minister of Safety and Security and others versus Kennedy and another. The High Court one was Kennedy versus Minister of Safety and Security, HC, MD, CIV, Motion, General, 2017-00393, to the judgment of 16 July 2020. And paragraph 2 in the Supreme Court, it says that transportation of inmates in police vans, blah, 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 while the vehicle is moving and such vehicle has no safety features to prevent physical harm to an inmate, is declared inconsistent with Article 8 sub 2b of the Namibian Constitution. The same one I was arguing about, how it's, our dignity is being infringed upon daily here. So yeah, it's all I can say. Maybe the DG of the judiciary, who reports to the Chief Justice, by the way, is not bound by the judgments. Maybe. I don't know. But it didn't arrive. It's not on the e-justice. It's none of them here to explain what is going on. Maybe I must now apply for a contempt of court proceedings, and so that my right to dignity is not continued to be infringed here. Stay these proceedings so that I'm not infringed by being put in this cage without proper facilities for trial. And also, lastly, Judge, so that on the 15th, you may remind this, I forgot to add this earlier, that on that day, we should be able to inspect where the docket will be kept here. The registrar had made those commitments. Where will it be kept? Not here. Clearly, if it's here, we're not here, because we won't fit together here. So, all these things.
Mr. Bernardt Esau, I will give you an opportunity. Anything to add?
About the transportation melody, I'm hearing it today because previously we've seen them in the comfort of a minibus coming to the High Court there. But ever since I came here, I have not seen them how they are being transported. But I'm hearing it for the first time that they're being transported in such a manner. I'll make inquiries. But I've seen them personally in the past. But I will inquire about the van now. The other issues, that then the issue of with regard to the registrar, my lady, I think they should direct their questions there. The state cannot do anything about that, my lady. That's all I can say now, for now, my lady.
Thank you. Any of the other counsel, anything to add?
Nothing yet, my lady. Nothing from my side. Nothing to add.
My lady, nothing in relation to the submissions of Mr. Shanghala. I just wish to place on record that, my lady, I did inform my colleagues that the files that I received from accused number 1 are indeed in the quantity I indicated to the court on the last occasion, with the court's ruling in relation to delivery of hard copies, which applies to the applicants in the matter. My lady, I also just wish to request my colleague to avail that. We spoke about it. I don't have a problem receiving it in digital format, because they undertook to do so once I provide a flash drive. But if they can provide it in hard copies, since they are going to be doing the copies for the others, it will be more convenient, my lady. May I please?
I would suggest they can talk to each other. Mr. Bernardt Esau.
My lady, the documents which were given to him pertains to accused number 1. Accused number 1 is facing only one section of the case, the Namgoma part. His name, it doesn't appear in the Fishco documents. So he was not given those documents. He was also given documents relating to Namgoma part of the case. And Namgoma is not mentioned in the Fishco section of the case. But if he wants those ones, since they are his client is not involved at all, we cannot give them in hard copy because it's difficult. It's a difficult task to make those copies. As it is now, we are almost a 3/4 way making the copies requested by accused number 1. So him, we can give him a soft copy, the Fishco side of the case.
Yes, I cannot see. I think that would be sufficient, Mr. Ilago.
Well, my lady, yes, I made the submission in view of the fact that they are doing it, and
yes,
an additional copy would be convenient. But on the issue of my colleague stating that my client is only charged with things relating to Namgomar and not Fishco, there is a common purpose allegation, my lady, and I need to sift through to see whether or not what is being mentioned in Fishco might be responded to. But I will speak to my colleagues and see what is the most convenient way to go about it, my lady. Just for practical purposes on how to get the documents.
yes, thank you.
May it please you, my lady.
May I reply to what was stated by the state?
On which aspect?
The aspect that apparently he has seen us in a van.
Minibus.
In a minibus.
Yes, you may reply briefly.
Yes, Judge, for the past 6 years now, our rights have been violated. And I have stood here and I've repeatedly requested protection from the court. The previous presiding judge was very indifferent. Mr. Marandeza has been consistent. He really doesn't take these serious when we allege our violations of fundamental rights. Mr. Marondeze is categorically not telling the truth. In fact, his relationship with the truth is one of a stranger. I had used in his language, and then the previous presiding judge's language, a word that perhaps if you understand it in your own language, maybe it means something. So if you speak Afrikaans and you say, maybe you would understand it better. I said, Arikunyepa. He lies. Judge, this is not an accusation. It is a statement of fact.
I think we should approach each other with the necessary respect that this forum demands.
No, Judge, I'm stating a fact. I'm putting a fact to you that he lied when he said that we were in a van, that he did not tell the truth. That's what I'm saying. I'm not saying, oh, he's a liar, he's a liar, he's a liar. I'm saying he lied in front of you. He lied. You could have heard also from the chorus of discontent. It is really, Judge, I know, Judge, you see, this is the thing. If you are an organ of the state, it doesn't mean that you should protect the state, Judge. Here this person is lying. Please. Lastly, Judge.
Mr. Shanghala, may I inquire who brings you? Is it the police or correction service?
It is the police. They apparently, when I requested the previous officer in charge, why that is done, he says that there's an MOU between NAMPOL and the NCS. Because if you read the NCS Act, I'm still in the custody of the officer in charge under Section 18 of the officer in charge of the Correctional Service Act, of the correctional service that I'm at, in terms of the Correctional Service Act. He then has to request the police when they have manpower issues. So they've done an MOU over and above the agreement, and when, for instance, people who have been convicted of crimes involving violence are going to banks or are going to the court, they go in a van or they go in a sedan. I am put in a bucket. Forget the fact that I am a previous minister of this republic. Forget about that fact. But it's important. It's how we treat our leaders. Okay? No, because in other countries, people even get house arrest and you can go to court. But I'm being put in a cell, I'm being driven around in a bakkie at breakneck speeds. Forget about that fact. Here you have individuals convicted and they are treated better than me. This is the prejudice that I'm saying. I'm not going to get a fair trial here, Mike. I already don't win anything. Yeah, simple. In fact, Judge, I don't know. I'm sitting here and I'm wondering, because my colleagues will ask me, the documents that were availed to us that you say we are not entitled to, should we give them back even? I don't know. These are the things I'm talking about. So anyway, I've made my point. Let's just hope that my rights will be protected further.
Thank you. Yes, as regards the stating here is hearing Monday next week, I would like you to talk to each other. We cannot proceed with this trial without everybody being organized and literally everybody being on the same page. We will sit here for days and days, this person referring to page 2 and that person referring to page 5. There will have to be a uniform order to whatever is contained in the disclosure. I'm not suggesting that each and every page be numbered, but at least the documents must be indexed uniformly, and you will have to speak to each other in that regard. So, Mr. Marondeze says, since you are representing the state, I will ask you to lead your colleagues in the discussion. It should take place within this week so that everyone can report back Monday next week.
Yes, Madam, thank you very much. Maled, I don't know whether the state should do more than it has done. There is already an index prepared which identifies the number of document in the docket, and in each volume is the document. And the disclosure was disclosed in volumes. And there's it's paginated that statement A1 of so-and-so is in volume what, and is of the docket.
Just speak to each other and make sure that everybody has everything, because we have to get at a stage somewhere or another where everybody is in possession of exactly the same disclosure.
Yes, please, Madam. What the state will do,
Indexed in exactly the same
what
manner.
the state will do today will, I have, except maybe for Elago, I have the email addresses for them. I will send them the index as it stands now of the docket.
Is that the totality of the disclosure?
Yes, every document is indexed.
Is accounted for in
Yes.
that index?
Yes.
We will then convene again next week, Monday, to point number 1 for that to be sorted out. I want everybody then to be in possession of an index. I also want everybody who is entitled to a hard copy of the disclosure, and I agree with Mr. Elago, if the allegation is common purpose, it is probably safer for him to have a complete set
Yes.
of hard copy disclosure.
Yes, Madam. It is common purpose in respect to Namgoma, and not common purpose to it. It can be common purpose to a charge you are not charged with. His client does not appear in Fishco at all. So it can be common
Again,
purpose.
then speak to each other
Yes.
so that everything does not have to be thrashed out in court.
As the court pleases, my lady.
Then next week, Monday, the case was set down from the 8th to the 19th of September.
Yes, my lady.
Our next court date then is the 10th to the 21th of November.
As the court pleases.
Mr. Elago, that gives you the whole of October, the whole of what is left of September to prepare.
I've started, my lady.
Yes, I appreciate that. But we will have to proceed then bar any unforeseen circumstances on the 10th of November.
As the court pleases, my lady.
Thank you. Case in remanded until the 15th of September, 10 o'clock, for a status hearing, accused 1 through to 9, then in custody at the Bintu Correctional Facility, accused number 10, bail extended on the usual conditions.
Mr. Court,
Mr. Court.
I